Today, let's talk a little bit about a private placement memorandum and what goes into it. So, a private placement memorandum or a PPM. So, let me share my screen and we will get into it. So, what is a PPM? So, a private placement memorandum, sometimes referred to as an offering memorandum or offering circular, is something that's provided as a disclosure document. Basically, it's something you give to investors that discloses everything about the investment. And the SEC's purpose is, this is all under securities law. The SEC is the main governing body on a federal level that oversees and enforces and regulates securities law. So the SEC's purpose, one of their main purposes, is investor protection, making sure investors are fully and fairly informed about investments. And a private placement memorandum, sometimes called a prospectus, offering memorandum, offering circular, is something that is used to make that kind of disclosure to inform potential investors. It's most commonly found under private placements, not public trade placements, basically when people are privately out raising money for real estate projects, hedge funds, alternative investments, crypto deals. So usually they're using Regulation D under the securities law, which is an exemption that allows that type of private raising of capital. Now, when do you use a PPM and what are the requirements? So a private placement memorandum under Rule 502 under Regulation D talks about the requirements for a private placement memorandum. If you look at the technical requirements, 506B, which is used pretty commonly by people raising capital privately, allows you to sell to accredited and non-accredited investors. So if you sell only to accredited investors, technically some of these requirements don't apply because the rule actually says if you sell to non-accredited investors under Rule 506B, then you have to furnish the information in Rule 502B2 at a reasonable time to the investors prior to the sale, meaning prior to them investing in your deal, you have to give them this information to non-accredited investors. Now, most of the time, people use a private placement memorandum and maybe it doesn't have all the same information, but they'll use it even when it's just accredited investors under 506C because it's really a best practice. It provides disclosure to potential investors and it helps protect the person putting the deal together that they've disclosed everything in terms of the deal. Now, what are the disclosure requirements under 502B? So there are certain both financial and non-financial information that has to go into the OM, Offering Memorandum, or PPM. And Rule 502 outlines what some of those are. Also under 502, you have to give any material that was given previously to investors. So if you've given an investor presentation or a webinar and a PowerPoint deck to one group of investors, you need to provide that exact same prior materials to future investors as well. So that's a requirement. You have to give them a chance to ask questions. And if they want to get additional information, they have to have time to do that. So you have to have a period of time where you say, hey, Mr. Investor, you can ask me any questions you want about this deal. If you want to ask for additional information, additional documentation, you have the right to do that. And you also have to tell them or advise them that there is a restriction on the resale of the security, meaning basically when you put your money in, it's going to be locked up. And you have to find an exemption under securities law to be able to resell your stock or units or whatever you're buying. And you have to notify investors of this. So the general categories that you'll usually see in a PPM or offering memorandum, first of all, your securities law disclosures or disclaimers, things like there's a restriction on resale. These securities have not been registered with the SEC or any state regulatory agency. You have the right to ask questions, some basic disclaimers under securities law. Risk factors of the investment, the business, the management. These are things like, okay, how could I potentially lose my money if I invest? So is it subject to, okay, well, this deal relies on interest rates. If interest rates go up, this deal could fall through or not make a profit, and you could lose your money. If it's a real property, it could be foreclosed on if we can't make the loan payments, and you'd lose all your money, things like that. The offering terms, use of proceeds. So, we're selling you shares of stock at $1 a share, and you can invest, you have to put at least $10,000 in to invest, that kind of thing. What are the proceeds being used for? Information about the company, its business, kind of like a mini business plan, or executive summary at least, is in the PPM saying, what are we going to do with your money? And what's the purpose of our company? And what are the securities being offered? So are we giving you stock? Are we giving you Series A preferred stock, common stock, units in an LLC, membership interests? What are the rights associated with it? Do you get a preferred return? Do you get dividends? What are all your rights as an owner once you purchase the stock? So the list under Rule 502 basically says, under B2, it says provide either non-financial or financial information to the extent material to an understanding of the issuer, meaning the company issuing the security, its business, and the securities being offered. So there's sort of this prefacing language that says, okay, well, all of the list of things we're going to put here, you have to provide to the extent it's material to an understanding of the issuer, its business, and the securities. So even though there's this lengthy list of things that we can go through, you only have to provide if it's really material to an understanding. So there could be things on here that really aren't material to what we're doing, and we don't have to provide that. So that's like a discretionary thing that either you or your securities attorney has to help you work through. Is this material? Is this something that I need to be able to disclose? The two categories are financial information and non-financial information. And Rule 502 refers to a securities form called Form 1A, and it references certain sections. And you have to provide the information that's listed in those, obviously, to the extent material. So let me show you a copy of what that looks like. Let me share that screen so you can see what that exact form looks like. All right, so here is Form 1A. Basically, this is a Reg A, Regulation A offering, and the list of information you would provide under Reg A, which is different than Reg D, but Reg D references back to, here's kind of our recommended areas that you should cover in your PPM. So it goes past the instructions to reference Part 2 and the financial statement, which goes down a little bit here. So it starts Part 2 right here on page 9. So this references part financial statement, but this goes into all these different things. Offering circular, same thing, PPM. Cover page, what information should be on there, the company, the price you're selling, any commissions paid, like to a broker. So this goes through a whole list of items, risk factors, a summary of the deal, potential dilution of, basically, are you going to get diluted if there's a future offering? How are they selling this stock? Who is selling the stock? Is it the company? How are the proceeds being used? Description of the business. Here's like the mini business plan, if you will, that talks a little bit about the business. And I'm rushing through these, but you can pull up, search Form 1A, SEC, and you'll see a copy of that form that you can obtain on the internet. And you can look through all these items. Description of the property. If there's any property involved, like if you're buying a real estate deal, it would explain the property. MDA, management discussion and analysis. So if it's a new company, this is going to be a very short section because it talks about prior results of the company. If the company's been around a while, this is a little bit more lengthy. It says the management's talking about, okay, here's our profit and loss statement for the last 3 years. Here's what's been going on with the company. Here's how we're making money or not making money, and the results of our operation. So talking about management, listing the officers, directors, managers, information about them, their compensation, their security ownership. So if you're the manager or officer owns 50% of the company, they're going to end up being listed on here and what they own. Related party transactions. So if the manager, director, or officer has a contract with the company that they benefit from, that might be a related party transaction that just gets disclosed. Information about the securities being offered. So, and here's a whole list of what rights you should disclose. If it has any of these rights, you should disclose it. Liquidation rights, voting rights, dividend rights, preemptive rights. If it's a debt offering, talking about what's the interest rate, the maturity date, amortization, things like that. And then it gets into part F/S, financial statements. This is where it talks about what financial statements you need to provide, if any, whether they need to comply, usually in accordance with US GAAP, which is an accounting standard. And so it kind of goes through the different requirements for financial statements. Exhibits, it isn't referenced that you have to include these exhibits. You don't have to worry about that. So basically page 9 through 26. Yeah, page 9 through 26 of Form 1A gives you a general outline to the extent material, the information that you should provide in a private placement memorandum. And so that's kind of a general quick overview. You can look up Form 1A for yourself or Rule 502 under Regulation D under the Securities Act to get a little bit better information and educate yourself. But hopefully this gives you a little idea of what the securities rules actually say should be in a private placement memorandum. When you go and you do an investment, you'll see, I've seen so many different types, some that are 2 pages that really probably don't comply with securities law, some that are, I mean, mine are usually 60 to 70 pages because I, go a little overboard, making sure we're compliant and disclosing everything we possibly can. But you'll see all different types of forms, and even if it's a 10-page, it might still be fine. It might still be compliant as long as it's disclosing that information that is material to the offering and required under whatever rule they're doing their offering. So thanks for watching. Don't forget to subscribe.